Yes, I'm live. And welcome, Grace, to my live stream and welcome you all to fight CPS and stop taking our children. I'm your host, Bob Pace, and we're here to talk about the child protection system, what I call CPS. Um, Let me put up um, a text message about one of the things you can do in this room. One of the things you can do in this room. Um, what you can do, and I have a banner up that explains it, is you can make a question or a comment about CPS. Please state your first name, your city or your county, and your state. I don't need to know your country unless you're outside of the United States. And then please put your country. Also, please tell me about your CPS case from the beginning to where you're at. Now, a second thing you can do, you can be a guest on my live stream. All you do is pick one of my 14 live streams and send me your name, your email, and your phone number to me. My email, bobp@vincentwdavis.com. I'm on Monday through Friday at 10 a.m. and on the weekend, Saturday and Sunday at 8 a.m. Every night of the week, again, I'm on at 7 p.m. And so when you send me that email, I'll forward it to my show producer who'll give you a link to StreamYard, which is what I'm broadcasting on. And StreamYard, you just copy and paste in your browser. Now, the rules are simple. We're very respectful in this room to one another. We're here to talk about CPS. There's no profanity, no eating or smoking in the room. Also, we do not use the names of children, social workers, or judges. And that's all there is to it. So look forward to you being a guest. I can take up 9 of you at one time. Now, lastly, I want to put my phone number up. That's where you can contact me at 626 698 0990, and you can talk to me. You can talk to me live on my phone. That's my direct line. So please call me at 626 698 0990. Now, you're probably wondering, the other number. Well, I have another number, 888-888-6582. That's the law office of Vincent W. Davis. He's my attorney, and he can help you out with legal information. He's been practicing law and fighting CPS for over 40 years. He once was in foster care himself, so he knows about the system. He knows about the system. And when you call in, you'll reach reception. Just tell them that Bob Pace sent you, and they'll know who you are. And when you do reach Mr. Davis, you want to make sure you tell him that I sent you. And he'll talk to you. You can retain him. Right now, where he works, his office is in Arcadia. He works out of Los Angeles County, California. And his retainer amount for a CPS case, general speaking, is $5,000, and he's a $500 an hour attorney. But it all varies on the complexity of the case and how long the case has been going on. If it's going on for a long time, it may be a different in price. Now, not only will he defend you here in California, he also will defend you in other states. The cost will vary. You just need to ask him. Like I've given quotes in Georgia and Wisconsin, it was $125,000 retainer and $500 an hour. But I'm glad you found me here. Also, that same number will reach reception, and they have all kinds of goodies for you. They have books for sale, they have guides, and they have also the schedule when everybody's on live stream. I'm not the only one that does live stream. Vincent Davis, my attorney, does it. And so does KK Richardson out of New York on Mondays at 8 p.m. her time, 5 p.m. our time here on the West Coast. And by the way, those times I gave you are West Coast times. I'm south of LA at a place called Surf City, USA, 3 blocks to the ocean. And I'm here to help you. I have lots of information. I have 43 years of marriage experience and have helped raise 6 children. I've also been fighting CPS for 25 years. And they are corrupt. The one that my case was, but there's also about a 50-50 chance that you get yourself a corrupt one. That's because I've talked to over 3,050 people approximately over the last 25 months that will tell you that. That's one thing that's bad about CPS. They are corrupt. It's all about money for them. $1 billion goes to the state, and from the state, $1 million goes to the county. Now, the names may vary, but I just call it simply CPS, Child Protection System. Now, in Orange County, where I was had my problems, is called the Orange County, it's called the Child Protection Services. Next door in LA County is called the Department of Children and Family Services. In Prescott, Arizona, home of the the Pink Ladies, these were crazy social workers, decided to put on the front of their T-shirts, professional child kidnappers. On the back, they put parents. Do you know where your children are at? That's wrong. They were fired. They tried to wear it in public, and only the 8 of them were fired. The director was. But anyway, they call their CPS the Child Protection Department of Children's Services, DCS. Then we go over to Richmond, Kentucky, and it's called the Cabinet. And with that being said, it varies from state to state, or actually varies from county to county. It varies from county to county and state to state. I dropped something. Sorry about that. Okay. I wanted to know if everybody's all right tonight. Also, I want to know if Michael is around. Michael's from Tennessee. He had a real important date today with the Alabama Criminal Court. You see, he had to defend himself and his wife when someone took a 2x4 and started to whap him. Now in Alabama, you can defend yourself or defend your wife. Now he's trained in martial arts. Um, he was not at a place that's illegal or anything. He wasn't doing anything illegal, and he didn't start it. They attacked him first. He did defend himself. But anyway, that's affected his CPS case in Tennessee. And they were trying to do a plea bargaining, and the plea bargaining was such a matter that it'd be reduced charges. He'd still have to plead he's guilty and still have to do a year of probation and a year of classes. And, it's terrible. When you accept a plea bargain, never do. If you're innocent, stay firm to that, and the jury will see to it that you're innocent, and that's in criminal matters. Now, in CPS matters, they don't have a jury. They don't have a jury, and that can be tough. That can be tough. Now, I have people in my room, and I'm thrilled to death, and I've already had 2 thumbs up. I have a thumbs up from, I think that is Indian language. I don't know. I don't recognize. I know it's not Japanese. I know it's not Korean. I know it's not Chinese. I don't think it's Arabic. I don't think I've ever seen it before. It might be Indian, or it could be other places in the world with exotic character about that. But I'm so happy to have that. That's really good. Now, you hear a knock at the door. Don't answer it. You don't know who it is. You're taught at a young age to ignore, to not talk to strangers. And when someone knocks the door and you don't know them, that's a stranger. So you got to be careful. So you got to be really, really, really careful. Now, the other thing you want to do is be quiet and move to the back part of the house. Also, don't let your family or your friends open the door. Because if there's a social worker and they usually have the police, it's very intimidating. If you open the door, they think they got access to your house and they inspect your house. And they right away want to take your children. Not because they're in danger. They want money because of your children. Every time they take a child into custody, they get $20,000 a month. They get a number from the county. Actually, the county pulls a number from the state that gives them the funds. It really is crazy how bad it is. It really is crazy. So, with a knock at the door, you don't answer it. Now, if you do encounter them outside, let's say you're in front of your house and someone approaches you at the porch, you be courteous to them. And if they start asking you questions, you want to say very nicely to them, is this regarding a legal matter? Because if it's regarding a legal matter, you need to have your attorney present. That's what the Constitution says. That's what your civil rights are. Anytime you're involved with a legal matter, you're supposed to have representation at all facets. So that is a red light in your head that says, I need to have representation. I need to get my attorney before we talk any further or before we have a meeting. And you certainly don't want to meet at your home. You want to meet at their office. You meet at a public place like the library, Starbucks, or McDonald's. Because there you can record video and audio. You need to document everything. Not only are you supposed to get an attorney, but you're supposed to document everything. Now, I told you that number, 888-888-6582, is to get Vincent Davis. I also tell you what he's trained and educated in. He is trained and educated in juvenile law, family law, and dependency law. Those three areas of the law are what's required to fight CPS. And you need someone to fight for you. You're probably going to say, oh, no, I can handle myself. Well, you can't. They're corrupt. Only a good attorney will know how to navigate the system. I compare it like open heart surgery. If you have a heart problem and you need it fixed, you're certainly not going to get a plumber or a dishwasher or a salesperson at a store to operate on your heart. Now, I'm not putting down those professions. Those are honorable professions. They're important to have. But like in a doctor going to operate in the heart, it has to be someone that's gone to medical school, done an internship, has mentored another doctor a long time before they start cutting open your body and fixing the heart. Same goes for CPS. They'll lie, and they will certainly hurt you and retaliate you. My social worker did with our case. In fact, they encouraged her daughter, 12 years of age, to divorce their parents, to change her name, to seal her original birth certificate, to get a new birth certificate, and a second social security card, and be adopted. She wanted nothing to do with us parents. And it's sad. It hurts me to say that, but it's really sad. I still have not regained from it. And it happened to me in 2017 when she did that at the encouragement of the social worker, her CASA, which is a court-appointed service advocate, and the judge. They all were behind it. How I knew? There's a video recorded of my daughter talking with the CASA work, talking to the judge, how great she is to have her freedom. See, that was the sad part about it. There's nothing wrong between me and my daughter, or between my wife and my daughter, but CPS orchestrated and sabotaged my wife and our daughter. Never gave me a chance to see our daughter from day one. It's really crazy the power the children get at age 12. It really is crazy. Hey, Michael. Oh, no. You went ahead and accepted the plea bargain. Oh, God. How are you a felon? I thought the plea bargain was going to send it to a misdemeanor. Michael is from Tennessee. I was trying to talk to Michael this morning. I got so anxious, I got scolded for starting my show too soon. I wanted to talk to you before you went to court. I wanted you to fight that case in Alabama and not accept a plea bargain. And I even stayed a half an hour later to make sure I was there to help you, Michael from Tennessee. Anyway, Michael, tell me the bad news or tell me what happened today at Alabama criminal court. I'm all ears, Michael. It was supposed to do what, Michael? Tell me more. Waiting for Michael to talk. You want to call in, Michael? My phone's ready to take your call. Good evening, and you've reached Bob Pace's live stream. Who do I have the pleasure of talking to?
Yes, sir. It's Michael Rollins.
Oh boy, Michael. I was hoping to talk to you today. I came on early on the show. I was anxious to talk to you. I came on too early and I was scolded by my show producer starting the show too soon. And now she's going to wait to the bewitching hour, like 1 minute to the show time, to create a show for me that puts me in a lot of stress. Anyway, I stayed a half an hour late to the show to hopefully talk to you. So, did you take the plea bargain?
Yes, sir.
Oh, boy.
Not the one that was offered to me yesterday, though.
No, I told you cannot bargain with these people. They're corrupt. They're corrupt.
Literally has tears in his eyes.
I mean,
He wasn't going to take the plea.
so did you talk to the two attorneys? What did the criminal attorney say?
charges, but it could take up to 2 years.
Okay. I know it's less time with your kid, but see, with a felony and a conviction, your job market ability is going to be nil. And with a felony, you're going to be able, you're going to see that the your life for the next year is going to be hell.
Right. They give me, like, I am literally a ward of I'm on parole for 18 months.
Oh, 18 months. They threw in an extra, wow. They threw in an extra, what, 5 months? See, 12, see, 13, 14, 15, 16, 17, 18, 6 months more. They want to keep you for a year and a half. All
The
be
judge started tearing up. I almost started crying. He started not successfully, and I told him, I said, sir, I need to settle these charges immediately. They're keeping me from getting, because he was trying to say that there's no such thing as and this was the exact opposite of what my lawyer was saying. The judge was saying that there's no such thing as a best interest plea, that I'd be pleading guilty. And I was told that it was me saying that I was not guilty, but in the best interest of my family, I needed to take the plea.
no.
And,
You see, your family's not going to see you for 18 months, and you're not going to get a job. You have a felony on your record.
I'm on parole. I'm not actually going to jail.
I guess you don't understand what it means about getting a job. Who's going to hire you with a felony? Well,
I'm on disability.
yeah. But if you want to get credit to buy a home, to rent an apartment, they're not going to give you that credit.
Believe me, Bob, I feel horrible. I really do.
Yeah, I feel for you on that. And I wanted to talk to you about it because I studied it and studied and studied. And I said, no, this does not make sense. I know that if you satisfied the criteria, that's why I think you'd be proven not guilty. If it takes 1 year, 2 year, 5 years, it's better to be found not guilty and have a normal life again. But you know what CPS is going to do? CPS is not going to give your children back. They're going to renege on anything they promised you. I am so sorry. You know how much I feel that I let you down. I was so behind you. And I wanted to talk to you before you went to court. Hi, Aaron. We got some sad news here. Michael from Tennessee has accepted a plea bargain, but it wasn't a misdemeanor. It was a felony. And he's got 18 months of parole and 3 years of probation. You see, the difference between parole and probation, let me tell you the difference. On parole, there's more restrictions on you. And you cannot make any mistakes in those 18 months. Then you got another 3 years of probation of somebody coming to your house every week to check to see if you have a knife or a gun, to search your house. And your neighbor is going to wonder, why is that guy dressed in battle fatigues, the sheriff, coming to your house once a week? Also, you're going to have to go to the probation guy every week and take a drug test. You said you don't do drugs, they still give you a drug test. So you got that to deal with. Then if you
I was fine with all of that. I wasn't fine with, like, when I told the judge what was going on, at first he explained to me that there wasn't a best interest plea in the state of Alabama. And I said, but sir, this is the best interest plea. The only reason I'm taking this plea is because I go to court tomorrow to try to get my kids back. And these pending charges is the only thing that's been holding me back from moving forward in this case. And
what guarantee?
the only reason I am taking
Yeah. What guarantee you have that you go to court tomorrow and CPS is going to give your kids back? What guarantee?
No guarantee.
Exactly. And why would they? They have a convicted felon who's now on 18 months of probation and
Oh, three years of probation.
well, 3 years of probation, but you got you're on parole for 18 months and 3 years. So you're going to be on that thing for 4.5 years. Your life is going to be miserable.
I
And
stayed in touch with my CPS lawyer the entire time. As soon as I found out that it was going to be a felony and not a misdemeanor, I had my wife step out of court and call him, and he said that even if it was a misdemeanor, that they would because it was 3 years ago that it happened, that that he would be able to still work with like it doesn't matter that they're moving it to up to a felony, that he'd still be able to work with it because it was 3 years ago. I've since then done anger management, I've since then done domestic violence, since then done counseling, and he's like he'll still be able to work with it. So we kept in touch with him the entire time. We went and seen him before I went to court. That's why I wasn't able to get on the phone with you.
I know. I just did not feel
So I
comfortable
felt
about
bad
doing
about me
the
either.
plea bargain because I made the same mistake and I went through hell for a year. I'm still going for a hell for a year. I had to accept a misdemeanor instead of going for a jury trial that would be found innocent. And every job I apply for, I'm dinged because of my guilty plea with CPS or with that criminal charge they did by the district attorney. The plea bargain was terrible. I had to take a drug test. I never did drugs in my life. Every week for a year, 52 drug tests. And I,
I would have to report for parole, but once a month.
well,
And I told you, the judge teared up when he seen me. When he seen me beforehand, throwing myself at the mercy of the court and telling him that the only reason why I was accepting the plea was because I had court tomorrow and that I wanted to move forward with getting my kids back. He walked out of the courtroom. Like he teared up and walked out of the courtroom. He said he was going to get another judge, that he didn't know if he was going to allow me to take this plea. He asked the DA, why in the world can't we get this man a trial next week? And they was like they didn't have anything till July. Um,
oh, they're making an excuse. They're trying to make money off you. They're trying to make money off
well,
you.
this judge was on my side. Like, he did not want to allow me
Well, doesn't that tell you something?
like 18
I mean, when he told you do
Yes,
not
sir.
take the plea, do not take the plea, why did you not take the judge's advice?
Because I've got DCS in the back and my kids in the back of my mind. This is the only
But do your
that
kids
I've
want to
been able
deal
to
with
do while
somebody who's in
being
prob?
still.
Yeah, but does your kids want to deal with a dad who is on probation for 4.5 years?
Yes, yes, they would love to be home with me. And,
They're
um,
not. They're not. And what's going to happen with CPS? They have a conviction, so they'll try to terminate your educational and physical custodies of your children. That's the next thing that's going to come down you. They're going to come down hard and take your.
the reason the way they explain it to me is that because I have these pending felony charges, because they were pending and not settled, that was that was the only thing that was holding me back.
Good, you
And the
still haven't
fact
given me a
of
good explanation. You don't understand. You're still guilty.
that they could at any time, I could be like if they say sent the kids home for a 90-day home trial visit, I have when I have 4 court days every month. incarceration to where the kids are left without a father.
They're still left out without. How they're going to have a father when you're on probation and you don't have legal or custody rights? You won't have visitation with your kids. So they're going to be without a father for 4.5 years.
Well, let me hope I can trust my lawyer, is all I can say.
Well, both your lawyers didn't tell you to do the plea bargain. And the judge.
Yes, he did.
Oh, which?
Both of them did.
Oh, they both said the plea bargain. Then I stand corrected. I can't argue. I can't argue against a attorney. I guess they know what they're doing. I don't. It doesn't make sense to me.
The one was a good attorney. I know for a fact he was a good attorney. And the one in Tennessee, when he could have spent 30 minutes with us, he spent 4 hours with us. Well, we're going over videos of us having fun, my kids and us having fun at the visits, and putting him. He literally said that I couldn't imagine this being like that being him. He had kids. He had a phone call with his daughter when we were in the room, and he was like, I couldn't imagine being in your situation. You know, you loving your kids, you doing everything that like really see that he cared. Like I felt the presence of a man. Have you ever been around a man that you know is a man of God just from the sense of his presence? Like that's the presence of this man that I the first time I ever met him, the first thing I ever said to him is, "You were sent by God as the guardian angel to my family."
Well, they're not. They're not guardian right now. They're not guaranteeing, and tomorrow it's going to get sadder for you. You had the law on your side. You have something called standing your ground law in Alabama. You could stand your ground, and there's a criteria for standing your ground. There's a legal process and a proof, and you met them all. We went over that. We went them. We went them all. I don't understand. Oh boy. Well, they have 2 years, but there's something called a speedy trial. It's your constitutional rights that they can't stretch it out unless you ask them to stretch it out. They can't stretch out a case unless you asked it.
Believe me, I'm beating myself up.
I know how hard it is. There are three key provisions. No duty to retreat. You don't have to run away if you're attacked first in a place where you have a right and aren't engaged in illegal activity. If you weren't holding up a bank or doing drugs or stealing something and someone came and attacked you or your wife, you can defend yourself. You have a right to stand your ground. You have the right to use force, including deadly force, if you reasonably believe it's necessary to prevent the death or serious bodily harm or serious felonies like rape, kidnapping, or robbery.
Right.
I
know. Like my lawyer said, the same thing is that we could beat this case, but it's when we try this case that's the thing is that the DA keeps putting it off and putting it off and putting it off.
He can't keep putting it off. They did that for me for a year. And I did not know any better. I should have said, I want a trial now. I want you to pick the jury. I want to have a trial now. The reason why I accepted them to keep it off is I thought there maybe was a plea bargain that'd be acceptable. But like a fool, I took the plea bargain, and for a whole year, I was miserable. And since that year, I have not been able to find work. Or I can't even rent a place right now. I can't rent a place. I'm sorry. Well, if you wanted to fly somewhere on an airplane, you have to announce them that you're a felon. If you go through a security check at the airport, you have to announce you're a felon. You don't understand what that does to you. If you get stopped by a police for a traffic violation,
I do. I understand.
what happened to the misdemeanor? Why did they not? Why did the district attorney change it from a misdemeanor to a felon?
She knew that I wanted to get this result today, and she did not want to do it my way. She wanted to have it her way.
Then you should have been. That should have been a red flag to you to say there. I'm sorry, ma'am. I had agreed on a felony. I mean, excuse me, on a misdemeanor, but you're doing a felony. I don't want a plea bargain. I'm out of this.
He never even come in the courtroom. The judge is the one who had to look me in the eye. He figured up and went down to the room.
Well, I would too.
Said he was going to talk to another judge about it because I had been misinformed. And while he was out, my lawyer told me that it wasn't going to get resolved today, that he wasn't going to accept it. And the assistant DA told me to say that I spoke to my lawyer that I'm taking the plea because of the evidence they had against me. I feel the plea is in my best interest.
What evidence? You told me that you satisfied the what? What evidence do they have against you? If they, if they had a good solid case on you, they wouldn't offer you a plea bargain. If they didn't have a solid case, they wouldn't offer you a plea bargain. See, they didn't have a solid case. That's why they offer you. That's the red flag. It should have told you there and everybody else in the court, including that attorney, hey, there's a red flag. They're offering me a plea. There's something going on. When I held mine for a year and they offered me a plea, I was so emotional, distraught because my case was on hold and I thought it was the right thing to do. And that was wrong. I should have said, I want a jury trial. Let's go for a jury trial.
Right. Even if I had a stand your ground trial and the judge didn't dismiss the charges, if I would have went before a jury and there would have been one man on that jury that would defend his wife against a male attacker that was twice his size with a 2x6 in his hand, with no way he was gonna find me guilty. With no way. Not no country boy from around here. I know that for a fact.
Yeah. Well, hold on a second, Michael. I got several people that have asked me questions I need to answer. Aaron is saying that the child protection system in Tennessee is going to use it. The DCS is going to use this against you, your felony conviction. And she feels you don't necessarily have to settle to get your kids back. DCS is trying to use charges on my records from 15 years ago. Erin is being records she has on her record from 15 years ago that are trying to use on her. That's how corrupt DCS is in Tennessee. Department of Children Services in Tennessee is corrupt. They're going to use your conviction of felony. She also says you're not going to be able to leave the state even without permission from his probation or parole. You won't be able to go to another state. Let's say you want to go to Kentucky or you want to go to Washington, D.C. You can't go. Well, I know that, but some people. Well, now you can't go to Alabama. Then how are you going to go to Tennessee? They don't care. You have a felony. It's against the law for felons to go across the state without permission.
Because I already live here, it's okay for me to be in Alabama and in Tennessee.
Okay, I don't know. I mean, I'm not a lawyer, so.
Right. No, I'm just saying they're going to apply to me the date that this happened, I moved to Tennessee. So I'm I talked to the parole officer about that too, because I thought that was true. I was like, doesn't that mean, this? I'm in parole in Alabama. Like, is that okay? And he said, yes, there's not a problem with that. That they might possibly be able to move my parole to Tennessee so that it's closer. And I'm like, no, I don't necessarily want to do that. It's just, it's a drive. It's an hour drive either way.
Yeah. Well, I'm really feeling sad for you, Michael, but you're a grown man and you listen to your attorneys. And if both attorneys say it's a smart maneuver to do, then that is your legal advice. And you'll have to go with that. Hold on 1 second, Michael. Hold on one. Okay, I'm back. I'm sorry, Michael. That's my son, and we're talking about Christmas. He's moved out, and so he's 20 years old. He's in college, and we are talking. Anyway, I'm family. I have family, and Amanda Jean. She's from Oregon. She's part of an Indian tribe, and she says hello from Oregon, sending good energy. Aaron asked you a question. Did they have any evidence? And your answer was no. You could beat the charge. You just didn't want to be stretched out and have a longer time getting your children back. And Amanda Jean had a warm welcome from Aaron. Thank you, Aaron, from Tennessee. Aaron further says, and BTW, my charges 15 years ago are misdemeanors. So Aaron had charges 15 years ago as misdemeanors, and CPS is still using it. What guarantees you that the Department of Children's Services, DCS, is not going to use the felony against you seeing your children?
The only guarantee is that they have already used the fact that they were pending charges and I could go to prison for them at any time. That's what they were using against me. They moved my wife up to 8 hours a month, left me at 4 hours a month because these charges were pending.
Well, we'll see tomorrow how many hours a month you can still see your children. I hope and pray that this is the right maneuver you did and that you will see your children. But I also hope and pray that being a felon is going to change your lifestyle immensely. You can't work with children. Did you know if you're at a church and you want to help out with Sunday school, being a convicted felon, you can't work with children at Sunday school. You can't volunteer to be a teacher's aide at public school. You can't work at private school being a felon. Any place that involves children, you won't be able to. And anytime there is a crime being committed, you can be easily convicted because you're a felon, meaning that they can think you did the crime.
Right. No, I know it's bad, Bob. I really do.
Yeah. I wish anybody out there listening could help me with Michael. I mean, I know that we all are praying for Michael. It's a horrible thing to go into a court and be pressured. I was pressured after a year and I accepted a misdemeanor, and I wish I never did. That full 12 months was terrible that I went on probation. I saw a probation guy every week. I had my house searched every week. My neighbors were asking, does that guy live there? I said, no. He's an old high school friend. He stops by, he's doing jobs in the area. I tried to wave it off. But they would come by and tromp through the house with their boots. It was terrible. And then I'd try to apply for a job. And they do a background check. They do a background check. Oh, anyway, so what's your game plan tomorrow? What is your game plan tomorrow? I can help you.
My lawyer took down every video that he said, if he went off of the record, he fully expected, when we showed him these pictures and the videos, he fully expected to see 4 children tucked in a corner, twiddling their thumbs, not socializing with their parents. And that's the way they were trying, CPS and Omni were trying to say the visits were going. And he said, so that's what he expected to see. But he took like 20 videos of us interacting with our kids, playing with our kids, different pictures with us playing with our kids at the park. And the video of the Army worker that lied during the meeting and said there's been problems at every single. She lied during the meeting and said there's at every single visit. So my wife looked at her phone when me up, so excited because 2 visits ago, she said the exact opposite thing. She said that there has never been any problems, that it's always been positive and good interaction with the children.
Well, what are you going to tell tomorrow? I mean, how's your attorney? What's he going to talk about tomorrow in CPS court?
It's the visitation plan.
Okay. And you're going to ask for 8 hours or more?
I'm going to ask for them to reinstate our visit. And see, the hearing is really just whether or not they're going to take our visits from us and keep our visits from us, and if they have any evidence against us.
Well, they have now. They have new evidence. You're a convicted felon.
My evidence is I'm not going to prison anytime soon.
Okay, let me tell you something, the difference between prison and being a felon. All people that are incarcerated are felons, and they go to prison. Because you didn't go to prison does not mean you're not a felon.
I'm saying that the reason why they've been holding these charges against me from moving forward and getting my kids back was because they said that any time I could be shipped off to prison for 7 years.
Okay.
And that's not
Okay. Okay.
but that's also these charges, so there's no more pending charges against me. That's what they've been using against me.
Well, there may be no more penalty charges against you, but CPS, every CPS case I know, if there's a convicted felon, they're going to use that against you on having legal custody and physical custody of your children and visitation. Yeah.
That's what I've been thinking too. That's what I've been thinking too.
I'm
That's all I can think about.
I'm just thinking that you, first of all, you can't trust your CPS entity in the child protection system, which is called DCF in Tennessee. You can't trust them. Erin right now is telling you, and she's from Tennessee, and she says She has felonies. They're being used against her 15 years ago by the Department of I'm going to say CPS. I can't use the other acronyms of other states. I get confused. Of CPS. Yeah. Of CPS. She is saying that they're really giving her a hard time. Okay. Well, it's getting close to my 8 o'clock hour. I have to do my show over in 3 minutes. And I'm going to pray all night that Michael is successful in what he thinks he's going to get tomorrow in court. That he's going to get visitation with his children, and they're not going to bury him further because now he's a convicted felon. Okay, Christina's asking, here's what happened. Michael was at a safe space, and this guy took a 2x4 and was swinging at him and hit his wife. Michael is trained in martial arts, and he fought back and protected his wife and himself because he felt he was in danger or could be killed. In Alabama, you have that right to defend yourself and use whatever is necessary to take action against the guy that did that. They don't have evidence against him as a felon. The felon was a plea bargain that the court, the district attorney's office wanted to punish him further and make him agree to that because it was wrong. The judge cried today because he knew that Michael did the wrong decision. Because Michael did not want to wait the years that you have to wait supposedly for it to come to trial. I cannot believe against your constitutional civil rights, you're entitled under your civil rights a speedy trial. The only way you get away from a speedy trial if you delay the trial, not the people doing the trial. Let me see here. Let me look up one thing in Alabama. Alabama. What are the rights? Okay, what are the constitutional rights of a speedy trial? In Alabama, the constitutional right to a speedy trial comes from the Sixth Amendment of the U.S. Constitution. It guarantees trials with undue delay, interpreted by Barker and Wingle factors, the length of delay, reason for delay, defendant's assertions of the rights, and prejudice to the defendant. Alabama has its own statutory projections, reinforced by recent legislation like the 2025 Speedy Trial Act, to address the backlogs, particularly for violent crimes, ensuring justice, fairness, and swift resolution through assigned judges and fundraising. So it's your Sixth Amendment rights that are violated. Did you ever ask for a speedy trial? Michael?
Yes, sir. Yes, sir. The entire time I told the lawyers I needed these.
Okay. There's prejudice to the defendant. How did the delay harm the defendant? Lost evidence or anxiety? Alabama, like most states, supplement federal rights with specific laws and court rules setting time limits for trials. Recent legislation, the Speedy Trial Act of 2025, aims to reduce court backlogs, especially for violent crime, creating a fund for extra judges, court reporters, and juries, allowing visiting judges to decide to clear cases. You have a right to a speedy trial is protected by both the federal constitutional law and the state statutes, with recent laws emphasizing efficiencies for serious offense, ensuring trials happen fast. Article 6 of Section 6 of Article 1 of the Declaration of Rights. That right is protected by a case-by-case analysis. The statutory limit of your constitutional rights in both Alabama and the Sixth Amendment is 90 days under court rules, which can be extended and a more flexible constitution depending on a case-by-case analysis of all circumstances. Okay, what circumstate would exceed 90 days?
That if I would have been in jail, they would have sped up the process, but because I was in jail.
Here are the categories for going beyond 90 days. There are two of them. There's delays attributed to the defense. So, for instance, if you did not ask for a speedy trial, you want to take more time, then yes, it could be delayed. Second one is for the interests of justice. Now, I don't see anything here that says Alabama has a 3-year try for you to bring you to trial. All I see is 90 days. So that attorney that told you, where did he get what's his time limit, that attorney? If you ask for a continuance, that is excluded from the 90-day calculation. If you fail to appear, that does not count towards the limit of 90 days. If your mentally competent evaluation delays caused by a need for mental health assessment or evaluation to determine the defendant's fitness to stand a trial, sometimes over a year, are typically excluded. Discovery and preparation, delays necessary for the defense review or new complex evidence is another way of extending it. I see nothing about the prosecuting attorney. Changing counsel. If the defendant changes attorney, the new counsel needs time to set up speed with the case, which can lead to continuance. Delays in the interest of the judges. A judge can grant extension for good cause reason. Yeah, that's okay. Case complexity. For example, complex cases require extensive preparation time for both the prosecution and the defense. The court can determine the time limit should be extended. Unavailability of essential personnel. The unexpected illness, capacity, unavailable of a critical witness. Joiner with a co-defendant. If the defendant is tried with a co-defendant whose speedy trial is not run, it will be granted. Ongoing settlement negotiation. If both parties are engaged and promise to plea, a judge may grant a continuance. Court backlog emergency. While court congestion generally outweighs the state and constitution analysis. Speedy trial, a trial that lapses. I don't see anything in here. Well, okay. Let me look up further now. I'm going to go further on this. I'm going to go to can the district attorney extend a speedy?
For 2 years.
Um, what do you mean by that?
I wasn't. They had you have to. They have to have a grand jury indict you.
Right. I know what that is. The detective, wherever the arresting officer was, were you arrested, by the way, when you had that fight?
Well, one of the charges, yes. One of them, no. One of them, the DA or the sergeant on staff that night said that it was clear cut, stand your ground, and that he wasn't about to arrest me. If anyone got arrested, it was another guy.
Oh boy. Well, here's what in Alabama I found. A district attorney can seek extensions for speedy trial deadlines, but it's not automatic and requires court approval, often for good cause, like complex case. Was this a complex case? Unavailable witnesses, requiring extensions up to 180 days, or other specific factors. Under Alabama's. Okay, go on.
One of the things that extended the case was granted my lawyer money to hire a private investigator, and the private investigator had to be funded 2 different times because he couldn't contact the so-called victim, you know.
Well, I don't want to put down Alabama court system, but it sounds like it's really messed up, and I apologize. Even murder has no statute of limitations. I don't understand that. He's not okay, Christina. The problem is, Christina, you don't know the whole picture. He's going to go tomorrow to the CPS in the state of Tennessee for visitation rights. But now CPS now knows he has a convicted felony, and they're not going to give him. They're going to take away his children. Erin, who's in Tennessee, her crimes of felonies 15 years ago are being used against her. They are. She did. She had 50. She now tells me she had 2 misdemeanors 15 years ago. 2 misdemeanors 15 years ago. And they're using it against her. Misdemeanors. And Andrea is from Illinois, and I do have to end my show. I don't want to. I feel so bad. My stomach is really hurting there. Well, I know. I'm just saying, well, what do you need to do is you're going to have to wait till tomorrow. The damage is done. You have to live with it. And if you think you're going to get your visitation, it will show tomorrow. No, you can take it back. There's a way you can appeal to the court. They don't want to tell you that, but you could appeal. Well, you could say you were under duress. You could say you're under duress. It doesn't hurt to ask. And if that judge is the same judge, he may grant you that. Let me look that up.
That was one of the questions he asked me, and I said I disagreed with him.
Okay, here we go. Okay, here's your answer. A person in Alabama circuit court can likely change or amend their appeal the next day, provided they act quickly and file amended notice of appeal or appropriate motion within the overall deadline. Okay? It says jurisdictional deadlines. The most critical factor in Alabama appeals is a strict 42-day deadline to file a notice of appeal. So you can appeal that appeal. It's called a notice of appeal from the date of entry of final judgment or order. As long as a change is made within the overall window, it's likely permissible. The Alabama rules of appellate procedures allow for a minute notice of appeal, which ensures the court and opposing parties understand the scope of the appeal. This is the proper mechanism for change the grounds, other deals of the appeal. Now, post-judgment motions. The process can be effected if a post-judgment motion, such as a moderate motion to alter or amend a judgment under Rule 459 or a motion for a new trial was filed. These motions can pause the 42-day clock, and a new or amended notice of appeal must be filed within 42 days of the denial of the motion. Waiver of issues. Issues for appeal must generally be raised in trial court to be reserved for appeal. Simply changing the appeal grounds may not be sufficient if the new issues were not properly raised and ruled during the initial trial proceedings.
If I go to court tomorrow and they try to use it against me, so I took a plea for no reason at all, and they're going to use it against me, I would be able to go instantly and file an appeal. And are you sure that's with a plea deal?
This is what it's saying. This is what it's saying here in Alabama. Alabama Circuit Court can likely change or amend the appeal the next day, provided they act quickly and file amended notice of appeal. You need to ask that Alabama attorney. You have to, provide that and file amended notice of appeal for appeal. It says they can change or amend their appeal. Did you not accept appeal did you not accept that you're guilty?
Yes, I said I was guilty.
Okay. All right. What you need to do is you need to act quickly. You have 42 days. You have 42 days to file what's called amended notice of appeal. You can see how it goes tomorrow. And then you can get a hold of your attorney and say you want to file an appeal because it didn't go the way you thought it was. And you don't want to write that in the court documents. You say your grounds for appeal is that you're under duress and you misunderstood what the ramifications would be. And you can ask for a change of your appeal. You have a 42 window deadline, and you have to file what's called a notice of appeal by the attorney in court. You need to go look at Rule 59 in Alabama, Alabama Rule 59. Okay? Now, if no sentencing has occurred, that's a good sign too, because you haven't had your sentences yet. Did the judge read you a sentence? Michael? Michael, are you there?
Yes, sir. Sorry, I thought I was talking the whole time.
No, I didn't hear you. Now I just heard you. Now, have they done a sentencing for you yet?
Yes, sir. And also, he said during this plea that I was not able to appeal, that I was waiving my right to appeal.
Well, then
you sure that has to do with pleas? Because
it says here, he said you'll file a motion. The attorney will file a formal motion to withdraw a guilty plea with the court outlining specific legal grounds for the request. The court's discretion, the judge will review the motion and consider factors such as reason for the request, the timing, any potential impact on the prosecution's ability to proceed with a trial. Acting quickly is crucial. So I don't know if that judge, see, the thing is, the judge didn't want you to do that. So the judge didn't want you to do that. He will grant you appeal. And you have nothing to rule. You go to CPS court tomorrow. You hear what they have to say.
I could even say that when he walked out, because he teared up, when he walked out of the courtroom, the DA said to me and my lawyer, this is what he needs to say if he wants to settle it today. And he told me that to tell the judge that I spoke to my and that because of the evidence the state has against me, I think it's in the best interest for me to take this plea. So that's what I repeated to the judge.
And that came from who? It came from the district attorney.
The assistant district attorney, yes, sir.
Right. And that district attorney isn't there as your friend. That district attorney is a political position, and he's using politics because he's got a conviction. There are corrupt district attorneys. They always are trying to be elected. It's elected officials. Judges are elected. And he has everything the right to get that conviction because it'll help him politically. But I just think you got to see how it goes tomorrow in CPS court, and then get with your attorney and see how you can withdraw your plea of guilty. It's called manifest injustice to withdraw a guilty plea after sentencing. If you have sentencing, you do what's called a manifest injustice. A manifest injustice. But you still got time, okay?
Yes, sir.
So you're going to have the best of both worlds, it looks like, from what I'm reading in the law library. You're going to find out what CPS does tomorrow, the DCF does tomorrow with your case. If you can have your children returned to you for visitations, or you extend more visitation, or it looks like your CPS case is over, then you did the right thing. But if it looks like it's going to be negative, what you can do is get with your attorney in Alabama and file an appeal. And the judge is wrong, saying that you can't file an appeal. Everything that's done in court is open to appeal. Limitations are 15 days, 5 days. This one here is 42 days. Okay?
I really appreciate you, Pat.
Yeah. Now, Kristen Reynosa is going to help you. She's an advocate for people wrongly charged. She's done a lot of synopsis. So Kristen Reynosa will text you. She wants to help you, and I want to help you. Okay? And I'll be by here tomorrow to talk to you tomorrow. What time is your court case tomorrow?
Tomorrow night.
What time is your court case tomorrow?
9 o'clock in the morning.
All right.
9
Good.
o'clock in the morning.
Good luck with you with your case. And if you get home, I'll be live tomorrow at 10 o'clock my time. Okay. Well, Michael had to leave. I want to thank Christina Reynosa from Las Vegas, Nevada, being here. Aaron from Tennessee. Andrea Frascus from Illinois. Who else do we have here? We have Amanda Jones, the Native American Indian from Oregon, with her ICWA case. Then we have Michael, who is on the phone, who just accepted a plea of guilty, and now he's being charged with a felony. And that was regarding an altercation where he's defending himself and his wife. And he has a CPS case with his kids, too. So all of you, thank you so much for calling in. Yes, I've gone over a little bit because we had a good discussion. God bless you all. And I really want you not to give up. Come here first. Always fight for them. I'm going to put my number up of the Department of Government Efficiency. And then there'll be a short video that'll follow me. Please watch it. God bless you and have a great night.
A vivid picture is encrypted in your mind as the critics get in line like they're witnessing a crime. But then you notice there's a shiver in your spine from the feelings of discontentment and bitterness combined. Heartbroken when you listen to the judges. Another kid's innocence corrupted, and if you go against it, it's destructive. Consider this predicament the toughest, but we believe in a system fit for justice. Child Protective Services only pretends to save it. The one solution for this is worthy of instant praises. 30 years of experience with relentless cases. Allow me to introduce them. This is Vincent Davis, defending you when they don't think a mother fits the role. Is it juvenile dependency or government control? Observe the pain in their eyes. It's time for us to realize we are the last one.